Hello everyone, welcome to Legal Darshan. In today's video, we are going to talk about Vishaka versus State of Rajasthan. Now, this is case number 13 in the list of leading cases for AOR exam 2025. Okay. Now, let's before we go to the judgment, let's start with the facts of the case. In this case, what is happening? There is one worker named Bhavri Devi. She has been associated with the Rajasthan Women and Child Welfare Department, and her duty was to raise awareness and to make people aware that female feticide, child marriages, and every domestic abuse that is happening against women is a menace in society and it should be curbed at any cost. Now, back then in 1997, 1995, 1994, 1990s, the date as it stands, she was gang raped by a few men. Her husband recently has passed away, and she was gang raped at that time because she was raising awareness. She was stopping people from doing child marriages, and she was basically doing her own duty. Now, this case come before the apex court, and because we did not have any law regarding the violation of regarding sexual harassment of a woman at that time, especially when she is in her course of duty, so this case is coming before the Supreme Court as a violation of Article 14, 15, 19, and 21. So 14 is right to equality, 15 is no discrimination on basis of gender, race, caste, place of birth, etc. Article 19 is freedom to speak, the right of the freedom of expression, freedom to work, and Article 21 is, of course, right to life. Now, because we did not have adequate provisions at that time, these provisions of constitution were invoked so as to ensure that there is some level of gender equality existing in the society. Now, Vishakha serves as one of the premier cases, one of the versatile cases which is taking into account events of sexual harassment at workplace. It is considering Article 14, Article 15, Article 19, and Article 21, and it was held by the Supreme Court that if such kind of instances are happening at the workplace, of course it is a result of it will be resulting in gender inequality, as right to life and liberty and right to practice profession or to carry out occupation, trade, or business, or freedom of expression or equality is beyond gender. It is there for everyone. So if women are being subjected to such cruel attempts, such brutal attempts of being gang raped, then this is definitely a violation of gender equality. So then now what happens here is court takes into account some international instruments like CEDAW. CEDAW is Convention Against Elimination of Discrimination Against Women. The CEDAW stands for that. CEDAW, India is a signatory to CEDAW. And we also took into account the Human Rights Act, and therefore the court here in this case is formulating some guidelines, some kind of provisions which ensures that women are not exploited at their workplace simply because they are doing their duty. Right now, basically, this is the case which opened the realm of lawmaking in the arena of sexual harassment at workplace against women. So now this particular petition was filed in Supreme Court under Article 32. So you need to remember this petition was filed under Article 32 to enforce the fundamental rights of the aggrieved woman. But here in this case, Supreme Court felt that of course we do have Article 14, we do have Article 15, we do have Article 19 and 21, which are providing that there should be no discrimination against women. Women should be treated equally, but there is still a legislative gap which has not been filled, which is forbidding the act of sexual harassment for sexual harassment of women at workplace. Right. So now in this case, Supreme Court noticed that Since we do not have adequate laws, we find it necessary to issue some sort of guidelines which will operate as binding ones until the new law is in picture. Okay, so Supreme Court exercised its Article 141 powers. Article 141 power is binding powers, that whatever Supreme Court is laying down shall be binding as a law. It shall be binding as a precedent. So Article 141 was invoked here in this case by the apex court, in which Supreme Court has laid down certain guidelines in the area of sexual harassment of women at the workplace. Right now, we'll just quickly go through some of the guidelines. I'm opening the judgment for you. Just give me a second. Yeah. So here, we do have the judgment. Okay, I'll just open. Just give me a moment. Yes, so basically in this case, I'll take you through the guidelines. So the head notes, we can see the head notes in the judgment. Yeah. Okay, so head notes read that guidelines have been issued in this case. Now, let's come to the guidelines. These are some guidelines that the court here is observing CEDAW, and these are some guidelines that the court is laying down in this case. Yes, the court laid down the definition of sexual harassment. Now, having see what I was telling you here, that Human Rights Act has been invoked in this case, and because we do not have sufficient civil provisions to provide for specific protection of women, the court is taking note of that and issuing guidelines. So number one is that it is the duty of employer or any other responsible person in the workplace and institution to prevent or deter the commission of sexual harassment at the workplace, and provide dispute resolution as well when sexual harassment of women at the workplace happens. So the court is also defining what sexual harassment is. Sexual harassment includes such unwelcome, sexually determined behavior, whether directly or by implication. It could be direct or it could be implicated. It could be indirect as well. Physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, and other unwelcome physical, verbal, or non-verbal conduct of sexual nature. So, if all of it is happening at workplace and it is happening in the guise of, I would promote you if you do this to me, I would demote you if you don't do this to me, in the guise of giving some kind of benefits to the women at workplace, if this is happening, then it will constitute sexual harassment at workplace. Now, there are rules regarding prohibition. The court also provided formulation of a disciplinary committee, which is ICC. Internal complaints committee should be formed in every institution, and there should also be local committee formed, because there can be institutions where there are not more than 10 members or not more than 5 members. So in those cases, there can be a district level local committee where, if sexual harassment is happening to women at a workplace and a workplace is not having ICC, then the women can go and complain in local committee as well. So these measures relating to sexual harassment were being laid down in this case, in the case of Vishaka. Now, what is happening? These guidelines were issued. Court said that it will bind persons as precedents, as a law set by precedent under Article 141. But did instances of sexual harassment of workplace stopped? The answer is no. It didn't stop, because there is another case, Ashok Apparels. In that also, sexual Ashok Chopra versus Apparels. In that all, AK Chopra versus Apparel. I'm sorry for the confusion. In AK Chopra versus Apparels, again sexual harassment is happening. A person is taking her employee for a meeting outside the office, and there she is assaulted, she's sexually molested. And then when we talk of another case, there is one case, Medha Kotwal Lele. Often when we read Vishaka versus state of Rajasthan, we read Medha Kotwal Lele. Why we read Medha Kotwal Lele is because in Vishaka is coming in 1997. Vishaka is laying out guidelines, laying out a judicial guideline framework for prevention of sexual harassment of women at workplace. But why is it that even in 1997, when the Supreme Court is noting down that we do not have a law against it, why is that the government is not making law on it? This question was being raised in Medha Kotwal Lele versus Union of India 2012. In 2012, Supreme Court gave direction to the center to enact a law for prevention of sexual harassment at workplace. Then later on, then after the case of Medha Kotwal Lele, we had prevention of sexual harassment of women at workplace, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, which is also the PoSH Act. Okay, now this, you can say that this act is an aftermath of both, of two things. One was the Medha Kotwal Lele case, which is asking the court to please let center know that make this into an act. There is a dire need of it because there are instances of sexual harassment. And another thing that happened, the second factor that contributed to it was Nirbhaya gang rape case. So Nirbhaya gang rape case happening in 2012 shook the conscience everywhere of every person, and therefore a lot of laws against sexual harassment were being passed. A lot of development was happening in feminist jurisprudence, making measures for rape laws, measure for prevention of rape, prevention of sexual harassment, prevention of assault. So POXO, POSH, amendments in JJ Act, criminal amendment of 2013, all of it can be attributed to somewhere Nirbhaya gang rape case also. So Medha Kotwal Lele and Nirbhaya gang rape case is playing a greater role in waking up the center to make this legislation out. Now this legislation is a result of Vishaka guidelines and the Medha Kotwal Lele case where this act was set out. Okay, now this act is providing a protection against sexual harassment of women at workplace. It is providing for prevention and redressal of complaints of sexual harassment and for matters connected thereto or incidental thereto. So this act has been formulated in furtherance of Article 14, 15 of Constitution of India, Article 21 of Constitution of India, that women do have a right to live with dignity. And then we are also relying on some international conventions, of course, UDHR, the Human Rights Declaration, the International Human Rights Realm. We are also relying upon CEDAW and, of course, Human Rights Act and everything. So in 2013, we finally had the POSH Act, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act in 2013, which is, of course, a result of the landmark judgment given by the Supreme Court, Honorable Supreme Court, in the case of Vishaka versus State of Rajasthan. And further, the directions were given to implement it in the form of a legislation in Medha Kotwal Lele's case. So thank you, everyone. I hope this video was useful to you, and I hope it will help you to understand the origin of Prevention of Sexual Harassment of Women at Workplace Act. If you have any more queries, feedbacks, anything to ask, you may write down to me in the comment box below, or you may mail it to me at thelegaldarshan@gmail.com. The email ID is also given in the description box. Please stay tuned. We will be covering more judgments for the AOR exam. Thank you, everyone. Have a nice day.